Welcome to Looking at Legal Stuff. Today we have 5 hearings, including 4 pretrial hearings and 1 new update, in a case for grandparent visitation rights, after Dad and the stepmom abruptly stopped the granddaughter's regular visitation with her maternal grandparents, after Mom was sent to prison for 6 years. The grandparents claimed that they had a relationship with the child since birth, and that they saw the child regularly, including the first year that Mom was in prison. They claim that it's the stepmother, who's no stranger to the legal system herself, who's the one who began causing issues between them, and they fear that she's the one who's controlling Dad's actions. Today's hearings include an objection to the referee's order, a motion to stay pending appeal, a first attempt at an evidentiary hearing, a motion to withdraw from Dad's attorney, which was pretty surprising, as well as a short new update to enter the visitation order. Let's watch.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Mr. Bartel on behalf of defendant. This matter is before the court on the defendant's objection to the referee order. I couldn't tell from the pleadings in this matter, Mr. Bartel, is your client still incarcerated?
That is correct, Your Honor. There's no difference as to when we were before you last time.
Okay, I didn't know if she was still there or not. You can proceed. You don't have to reiterate all of it, but you can highlight in view of, I'm sure you've seen Ms. Reed's response.
I did, Your Honor. Thank you.
Okay.
Essentially, what has been labeled as a change in legal custody, Your Honor, I'm just going to quickly, if you look at the very end of Mr. Cronkite's motion when he filed it, he says that he comes to the court, quote, to ask for a permanent custody change. He says at the conclusion, he says, I want sole legal custody, no child support, no contact with the grandparents on maternal side. And not once is he asking for a change in parenting time. The best I can tell now that Ms. Reed is involved, she has now put some things in there regarding, yes, he has asked for a change in parenting time. That is not true whatsoever. He has asked for a change in legal custody, and that is what his motion is about. And obviously this court knows legal custody pertains to the important decisions regarding the children's health, education, and religion. There is a presumption, a strong presumption for joint legal custody for the parents to be able to deal with those important decisions. And with regards to here, Your Honor, the reason why it's important is this court had a 2-day trial initially, awarded joint legal, joint physical. Then my client did get in trouble. She is incarcerated right now. The court had an evidentiary hearing, left in place the legal custody, and changed the physical custody, Your Honor. Now, what we have here is there is nothing whatsoever in the motion presented by plaintiff that he is indicating that he has prohibited, prevented from being able to make those decisions with regards to the minor child. He doesn't even mention anything with regards to that. In fact, my client and plaintiff, at least according from my client's perspective, she thought they were actually on good terms. They had some conversations via telephone while she has been incarcerated, and he had indicated that he wanted to get along, and that had been going on for months. They had actually been talking about the child and everything. And then all of a sudden he files this motion. He files this motion after all this time, Your Honor. And if we look at the 4 corners of the document, we are in a notice state, and you don't see anything in there other than the bashing going on. We don't see anything in there where he indicates that he needs sole legal custody, that defendant in some way is not able to participate, that her activities inhibit the ability for the minor child to participate in all of those important decision making with regards to religion, with regards to where the child goes to school, or anything like that. So I would ask, just like I said before, we are in the same place in essence before. I think it was inappropriate. This court had previously heard it. We have an order put in place. In fact, an order that indicates when she gets out, Your Honor, what the court expects her to do with regards to getting to her parenting time and obviously the legal custody. So I think it was inappropriate. With regards to the evidentiary hearing, we'd be asked that this court overturn the referee's decision with regards to that.
Okay, thank you. Ms. Reed?
Our position that there has been proper cause or change in circumstance pursuant to Varka, as she has obtained new charges which she is incarcerated for. Those are drug-related charges, theft-related charges, and she was just sentenced on weapons and theft-related charges at the beginning of this month. We have some severe mental health concerns. We have severe substance abuse concerns. My client did request a change in parenting time because he requested no contact with the grandparents, and I do believe under the last order, the grandparents are the parenting time supervisors, and all of this activity happened while mom was living with her parents, and she wasn't exercising her parenting time pursuant to the last order. She was in Indiana collecting more felonies. She was on drugs, which is very concerning to my client when you have parenting time supervisors saying, mom's exercising parenting time, everything's going great, when she's actually not doing that. She's breaking and entering into people's homes, stealing vehicles, and doing drugs. There's concerns regarding the legal decision-making ability of mom due to her mental health, due to her drug use, and mom is doing whatever her parents are telling her. And that impacts my client's ability to make those joint decisions because he'll talk to mom in jail. One day mom will tell him one thing and be okay with a decision. The next day her parents don't like it. So she might call him and say, no, I don't agree to that anymore. Or my parents don't understand why I'm talking to you. And I shouldn't be talking to you. So these are issues that come up when my client is trying to make these decisions for these children. So we're requesting that the evidentiary hearing proceed.
Okay. Well, in this particular matter, the court does note that, again, the fact that she's incarcerated does make communication difficult, to say the least. And I think that the referee can take any inferences from the pleadings in this particular matter as well. And obviously, he probably did, in the fact that she was incarcerated and realized that the parties were not able to communicate. The court will, in fact, leave that order as it relates to the legal custody in place. All I would say is that if she wants, what it relates to the parenting time, if either party wants to file something in the future when she's out and has a chance of having parenting time, the court would hear it at that point. But I don't think it's something that really needs to be addressed at this point, because obviously she's not going to be exercising any parenting time while she's incarcerated. So, Ms. Reed, if you will, I don't know what's the extent of the order that's there by the referee. You can I can resubmit that order from this hearing, and then we'll address it in that particular manner. You can submit under 7 days.
The order from the referee is just setting it for an evidentiary hearing. So it's my understanding that we're dismissing that evidentiary hearing.
Yeah, we don't need an evidentiary hearing until such time as she is not incarcerated, and then it can be addressed at that particular point.
So the order under the 7 days says that the parties shall remain sharing joint legal custody.
No, I'm not ordering that. The referee is saying that they should continue the joint legal custody.
The referee set all issues, custody, parenting time, child support for an evidentiary hearing.
Oh, okay. Well, why don't we do this? Is just leave.
Your Honor, if I could, I would just suggest that at some point, I think it makes sense if, I mean, he obviously has the decision making. Like I said, he has not indicated that it's inhibited, that I guess that he could file a motion upon her release to deal with all of these, I guess. Otherwise, we're having an evidentiary hearing, and then 6 months later, maybe having another evidentiary hearing. That's what's going to happen, Your Honor. That's really what's going to happen. We're going to clog up, I think.
Why don't we do this, Ms. Reed, is we'll vacate we'll vacate the order for the evidentiary hearing and state that parties can refile at the time that she's no longer incarcerated.
All right.
You can submit that under 7 days. Thank you. You're free to go. Have a good
All
day.
right.
Thank you.
Thank you.
Court will note the appearance of Ms. Reed on behalf of the plaintiff, Mr. Bartell on behalf of the intervening party. The matter is before the court on the plaintiff's motion to stay pending appeal. Mr. Bartell has filed an answer. Ms. Reed, I don't need to, again, rehash your motion. If you want to respond to anything in Mr. Bartell's answer, go ahead.
It's just that we're dealing with a constitutionally protected right in this matter, Your Honor. We do not believe any evidence has been presented to rebut the presumption that is in place to protect that right. There is no risk of harm to the child with a denial of grandparenting time. There is a risk of harm to the child if grandparenting time is exercised, because this child does not want to see the grandparents, and to call her out of the house kicking and screaming would be traumatic to her. And that there has not been a best interest finding pursuant to MCL 722.27 B6, which is required by the court to conduct and place that finding and that analysis on the record, and that hasn't happened yet. So how this order kind of got entered, allowing grandparenting time, is backwards, is that all the requirements were not met. So we're requesting that the effect of the order be stayed pending appeal, or that it be rescinded and we go to an evidentiary hearing regarding the presumption and the best interest factors.
Okay. Mr. Bartell.
Your Honor, this court has every right under MCR 3.207A to issue a temporary order with regard to, quote, any matter within its jurisdiction. And that is right on point, Your Honor. And that is quoted from the court rule. And grandparenting time is within this court's discretion or within this court's jurisdiction. So clearly the court has the ability to enter a temporary order. It is a little confusing from plaintiff's motion. It kind of vacillates back and forth between whether this is a final order or a temporary order. Clearly it's a temporary order. They would need an interlocutory appeal in this matter. The court weighed everything that was put in the motion in answer at the previous motion hearing, determined there was a preponderance of evidence to rebut the presumption of the statute. Further, as we had put in our motion, the court had previous hearings in which this court had heard from Mr. Cronkite, and he had been under oath previously, where he had said that the grandparents were the ones who were really watching the grandchild and not Taylor Morgan. And then he does an about face under oath again when it is convenient for him to say, oh, they never even watched really the kid at all. So, Your Honor, I think that motion before the court here should be denied, since the court has every right and authority pursuant to the court rules. Thank you.
Thank you. Well, at the time that the court put in place the temporary order, the court did note, as stated by Mr. Bartell, what the status quo was, which is now disputed, and the plaintiff has delineated many reasons in the motion, but the court would note that, again, those are just allegations and conjecture at this point without having a hearing in this matter. And the intent was the court would have a hearing, but I was only maintaining the status quo on a temporary basis at this point. The court will not stay the order. If the Court of Appeals wishes to do so, they may do so during their review, but the court is going to deny the motion to stay the order in this matter. Mr. Bartell, you can prepare an order denying that motion, and that will conclude the matter for now. You're free to go. Have a good day.
All right. Thank you.
The next hearing was on July 15th, and I don't have that video, but we can see from the notes in Odyssey that the judge has continued to deny any change to the custody order. However, it was at this time that the judge went ahead and ordered the evidentiary hearing that the referee had previously recommended. He also warned Dad that he risks jail time if he doesn't start following the temporary order for grandparent visitation. Just 5 days later, There was a show cause contempt motion hearing for denial of grandparent visitation, where the court decides to hear the motion at the upcoming evidentiary hearing. He reminds Dad of the existing court order, and he's told he's expected to have the child ready to go for visitation.
Matter is before the court today, set for a hearing on the motion of the intervening parties. I would tell you that we had in this matter written out Taylor Morgan for today's proceeding. We received confirmation from the prison that they would have her available. We've been in contact with the prison now for about 40 minutes back and forth. They're saying they're having difficulties with their Polycom system, and they can't apparently get it to work. So they can't get her to appear because their system is not working at the current time. They said they're trying to fix it, but again, that's been 40 minutes that we've been on the phone to MDOC with multiple individuals, and really no answer as to when that might occur. We'll proceed. Ms. Reed, you had filed a ex parte motion. I will tell you, just so the attorneys know, I really don't like ex parte motions, but I understand with the short notice that you had to file something. So I'll let you proceed with that before we proceed.
All right, thank you, Your Honor. Yes, we filed an ex parte motion to adjourn and for a scheduling order because there's some Michigan court rules regarding service and notice that I believe have not been followed, and it prejudices my client and our ability to prepare for the hearing today. So regarding the Michigan court rules, Mr. Bartell was ordered to prepare an order under the 7-day rule at the hearing on 7/22 for the show cause. That was not prepared, not issued, not entered. Then there was a frivolous order to show cause, again filed by Mr. Bartell on 8/8. We never received a copy of that. That was denied, and it was clearly frivolous because it requested an order to show cause for denial of grandparenting time when grandparenting time order was already vacated. I never received a copy of that, was never noticed it, and we had to request certified copies from the court to get that order. And then again on 8/8, another motion to show cause was filed that I have not received or been served with. And then on 7/31, Mr. Bartell signed a subpoena to Grace Health requesting records. And under MCR 2.305A5, a subpoena to a non-party for deposition of records is required to be served on all parties on the day that it was issued. And we did not get that until a week later. I had to do due diligence and call Grace Health to see if those records had already been furnished before I could even file or try to file any protective orders in that matter. So that prejudiced us in trying to protect those records, finding out if those records had already been done because we were not served properly. The proof of service for that subpoena was not filled out properly, and no proofs of service for any subpoenas have been filed with the court before this hearing, which is a violation of the court rules. And then I was made aware that witness subpoenas had been issued. I was not given copies of those subpoenas, and I understand that Mr. Bartell's argument is that he does not have to give me copies of those subpoenas. And while that might be true, the subpoenas on the MC-11 form for the subpoenas that were required to fill out the proof of service very clearly states that that subpoena must be served and a proof of service for that subpoena filed with the court. Filing that proof of service gives me notice of the witnesses that he intends to call. And the due process of the Michigan court rules, case law, discovery, trial preparation is also that we do not have these hearings by surprise. And in this case, we are dealing with a constitutionally protected right of a parent, and I do not have any sort of notice of any other witnesses that Mr. Bartell intends to call. So we are requesting an adjournment, and I believe an adjournment is appropriate because I do believe Mom has a right to be at this hearing, and now she cannot be at this hearing, and for a case scheduling order with witness disclosures so I can have an opportunity to adequately prepare a cross-examination with my client.
Okay, thank you. Mr. Bartell, any response?
Yes, Your Honor. Unfortunately, I think that counsel on the other side has misrepresented not only facts and law to this court. And I'm a little dismayed by that, quite frankly. I will admit that my staff did not send out immediately the one subpoena to Grace Health. When I inquired to my staff, she said, "I'm sorry, Aaron, I didn't," and she immediately sent it over to Miss Reed. It's interesting that Miss Reed comes in here and says, "Well, I didn't have time." She had another week beyond then to file an objection. And usually how it's done is you make contact with that particular organization and say, "I'm objecting to this, hold off until the court decides." You file your motion, file whatever you need for a protective order. Didn't do any of that. I highly doubt that they were gonna file something since they still had 7 days, Your Honor, and they didn't do it. Further, I do not have to, under the court rules or the law, and I would love a court rule or a case from Miss Reed that says I have to serve on her subpoenas for a witness to appear to a trial or an evidentiary hearing. I have never done that. I have never seen an attorney do that ever, except Miss Reed. I've been doing this for 13 years. Unless every other attorney I've dealt with is in violation of law too, but she still doesn't provide a court rule. She says some vague thing regarding the subpoena. I do not have a duty to provide her a copy as to who I'm subpoenaing to be here. Number 3, Your Honor, with regards to the production of documents, I usually, as a matter of course, actually do provide whatever I receive from whoever I'm subpoenaing, those documents. I provide to the other party. I would like to direct attention to MCR 2.305A7. It says upon written request from another party. So they're the other party and payment of reasonable copying costs. The subpoenaing party shall provide copies of documents received pursuant to a subpoena. That is actually the rule. I don't have to provide it to her. I do it as a matter of course, and I did provide it to her. She just didn't like how it was provided to her. We sent it out via mail because we received an email, but via a secured system with Grace Health. I don't have some secured system to provide to her. She never said, "Aaron, can I come pick those up then? I would like to get them quicker." She could have done that. We had indicated that we had mailed it out the day before when she inquired about it. Pursuant to the court rule, I didn't have to provide it to her. That's why it's a misrepresentation, and I'm a little, not happy about this because she's misrepresenting court rules and law to Your Honor. Yes, the whole point of giving the other side notice as to receiving documents or other information from a third party is that it gives them the opportunity to object if they think that it's improper because there's privileged information or something like that. And she had ample time to object. She didn't object, Your Honor. With regards to the order that was not entered, that was not entered, but the Court of Appeals did already reverse. So I'm not entering an order that the Court of Appeals already reversed only on that matter. With regards to show causes are filed, and we just had one come back in the mail in which we had filed a show cause, and the court had denied it, I think based upon the Court of Appeals decision. We had sent over the denial to Ms. Reed. This is just ridiculous, Your Honor. I don't appreciate attorneys coming in and not citing the appropriate court rules or reading the court rules, and it's as clear as day, read them. We did comply with the court rules, except for, I will admit, we did send out a week late, and I apologize for that. But I think it's a moot issue, given that Ms. Reed did not even object or attempt to do anything, except she now wants to come into the court and complain to you. So I'm actually asking for costs for having to read this ex parte motion because there was factual inaccuracies and she misrepresented the law, Your Honor. That is not right.
Okay, thank you. Anything
May I
else,
respond, Your Honor?
Ms. Reed?
There was no misrepresentations. As soon as I got that subpoena, I immediately called Grace Health and was starting to leave messages because it does not make sense for me to file objections when the documents have already been produced. That would be a frivolous objection saying, hold on, no, Grace Health, don't send that if I don't know if Mr. Bartel's already gotten the documents. That doesn't make sense. It just doesn't. I'm going to file an objection saying, no, hold on, don't file these documents. I want to wait for the court when they've already been received. That's why I was making phone calls as soon as I got that late subpoena to try and see if I could file an objection. And I contacted the HR or the subpoena compliance director over at Grace Health, who gave me the information that the documents were sent via email to Mr. Bartel and when they were sent. And by that time, and when I actually found all the information, it was already done. I can't do anything about that. Now, granted, I should have been immediately served with that subpoena. I should have been. And while Mr. Bartel says, he does not have to serve me subpoenas, he does not. What he does have to do is file those proofs of service so I have notice. And the Michigan Court of Appeals has upheld trial court decisions to strike witness subpoenas when there was no notice to the other side based on unfair surprise. And that's what these witness subpoenas are. It's unfair surprise. It's a trial by ambush. If I don't know that these witnesses are going to be appearing, if I don't know that they're going to be testifying, what they're going to be testifying about, who they are, and I won't have adequate time to talk to my client to prepare. And there's unpublished case law that does this, that says that there's an unfair surprise. There's published case law that says that there are no secret subpoenas to be issued, that the other side is entitled to notice about subpoenas and witnesses.
Your Honor, can I respond? Because once again, we don't have a good timeline here. Paragraph 14 of the ex parte motion. Petitioner's counsel did not provide a copy of the subpoena to plaintiff's counsel until August 7th, 2024. We just heard from counsel say again, I didn't have time to do anything. That's inaccurate. She said that supposedly Grace Health sent it over to us on August 12th, 5 days later, Your Honor. That is factually inaccurate. And she's still misrepresenting to the court. That is what gets me going on this. And so what in those 5 days did Ms. Reed do? She did nothing. Or she had a conversation and now she's still misrepresenting more to the court. Further, she keeps talking about unpublished cases. There's nothing in here. She had one case, it was a criminal case that said reference to stealth docket. I was doing some research. It was copy and pasted from some note in the court rule book or ICL that said that. Well, if you actually pull that case up, it is referring to when you are subpoenaing for information, documents, and that is correct. We don't want someone to gain all this information that we don't know what they're seeking from documents. That has nothing to do with subpoenaing someone to appear and attend, Your Honor. Because guess what? She has the ability to cross-examine those witnesses. That is the purpose. Okay. That it's just mind-boggling. She still can't cite any court rule or case law.
Okay, thank you. Well, obviously, in this case, it is now approximately 9:15. Matter was set for 9:30, and we still have not gotten communication with MDOC as it relates to Taylor Morgan and her attendance in this matter.
Yes, we did receive, I guess. They say that she can appear by telephone, but I have nobody here yet.
Okay, so we still have no contact there, so.
Yes.
In this matter, the court does note that the subpoena issued to Grace Health apparently, as Mr. Bartel acknowledges, that his office didn't send it out to Miss Reed for about a week. It was an oversight. And the court will not ascribe any improper motive to Mr. Bartel for that notice, but the court does note that Michigan Court Rule 2.305 parens A parens 5 does provide that a copy of subpoena must be served on all other parties on the date of issuance. All I can think of is I will tell you the United States Postal Service is far less efficient than it used to be, and mail sometimes travels at a snail pace. But the court would note that the court rules were adopted to provide fundamental fairness to all the parties involved in the litigation. And I understand that with this matter coming up, that petitioners may have been against the clock in preparation for their case as well, so you don't always have all the time that you need to get subpoenas and respond and things of that nature, but court does also believe that each of the parties are entitled to sufficient time to prepare their case and their defenses in the matter. And again, because of the fact that Miss Morgan, Taylor Morgan, is not able to be present and is not present now at this particular point, the court unfortunately is left with the difficulty in this matter of whether to proceed. And as Miss Reed, I don't know if she's received the documents from Grace Health yet in this case, but she hadn't when she filed that motion. And I think she's entitled to those documents to be able to know what's in them, because if she's going to effectively cross-examine, she needs to have them. As a result, the court is going to grant the motion to adjourn. And what we will do is be in touch with the attorneys to see when they're available. We don't have to appear next time in person as happened at this particular occasion, because obviously Ms. Reed isn't, we have Taylor Morgan can't. And so I think it's probably better and easier for all of the witnesses if they're able to appear vis-a-vis Zoom as well. So the court will do that. I am going to, so that there are no issues and no surprises, I'm going to order that the parties would, within 10 days of today's date, disclose all the names of their potential witnesses in this matter. Ms. Reed, you can prepare an order adjourning the matter and also stating that the witnesses will be disclosed within 10 days of today's date. With that, Ms. Reed, is there anything else further?
Do we have a date, or is it going to be a date later set by the court?
There'll be a date later set. I'm going to have to call both of the offices and see when both of you are available and when we're available.
Are there any witnesses in the lobby or Zoom?
Yes, I have Deborah Arnold, Kelsey Cronkite.
Okay, can we bring them in and dismiss them?
You want me to bring all of them in? Do you have also an Allison Martha? Is that one of yours?
Okay,
Are those your witnesses, Ms. Reed?
yes.
We'll
I
let
think
you-
Kelsey Cronkite was under subpoena.
Okay, you can contact your witnesses and release them, and Mr. Bartel will do the same. Anything else, Mr. Bartel?
Yeah, I understand how the court ruled, but, and I was just listening to what the court had said. I just want to make sure the record is clear. The court had indicated that cross-examination by Ms. Reed, she's actually the one who's subpoenaed, and it's her witness is the counselor. So it's not a cross-examination. So we were talking about preparation. It was her witness,
Okay,
actually.
that's fine.
That's number one. But number two, I just want to make sure that 2.3057 says I actually don't have to provide those documents to her. I just want a clear record. I respect the
I'm
court's
not
decision.
saying that you have to, I'm saying that she has a right to get those.
But she
Yeah.
didn't get them, Your Honor, is all
I
I'm saying.
understand.
I get
I
it.
understand.
I
But she wanted those, and I think you'd sent them, so she's gonna get them eventually as soon as the post office will get the mail to her, so she'll have them.
Well, I don't know if she got them or not. She never indicated that to the court. She didn't say. she
Well,
got them
just
on
for
Monday or Tuesday.
clarification, Ms. Reed, have you gotten those yet, or?
We did get them this week.
Okay, thank you.
So they-
Well, just prepare the order, submit under 7-day, and again, we're stymied somewhat because of the fact that Taylor Morgan is not able to be present. And
Well, I'm willing to proceed forward and have her appear at a later time if that's an issue for the court.
well, no, we will adjourn because as a party, just her appearing at a later date isn't going to help us, today's date if we can't get her on. Miss Taylor Morgan is what I'm speaking about.
I understand. I was just suggesting that she can testify at a later day. We've.
Not concerned about her testimony. As a party to the case, she has a right to be here when everybody else testifies.
Well, I understand. I represent her too on that, Your Honor.
Okay.
And I have a waiver of conflict of interest between the grandparent and her.
Okay.
So I just want to make that clear, is that there's a waiver of conflict of interest between that two, and as her counsel.
Bartel, just for clarity, when I reviewed the file, I didn't find any appearance on your behalf for Miss Taylor Morgan.
Well, not for, I guess, this particular hearing, I guess, if the court wants me to enter one, I can do that. I had just filed a motion for order to show cause, and I'm waiting for the court if it's gonna sign.
If you
it,
would,
but-
just to clarify and basically get the file in order, if you would do an appearance for her as well, and then that way we may not have some of the issues with MDOC that we're having today if you are representing her.
Okay, I don't know how that would clear the issues up, but I'll do that, Your Honor.
Well, we had, not aware, because you didn't have an appearance, not aware that you had represented her. We had her writted out so that she could be present for this hearing as a party to the case.
Okay.
Well, if you're representing her, then we may not have those particular issues. Do you want us to still writ her out for the next hearing?
Well, yes, I mean, in my experience, usually the court is gonna writ the person out even, maybe not always, but usually the court is gonna writ that person out because they have the, I think, better ability than counsel, even if they represent them.
That's
Yeah.
why I'm asking.
Yeah, I would like that, Your
Okay.
Honor. Yes, thank you.
We will do that, and at this point, we'll stand and recess, adjournment.
All rise.
They had a hearing on September 3rd that I don't have, where they discussed the attorneys choosing a counselor for the child to replace the counselor that Dad and the stepmom took her to without Mom's permission.
Court will note the appearance of Ms. Reed on behalf of plaintiff and Mr. Bartell on behalf of the defendants in this matter. The matter is before the court on the Ms. Reed's motion to withdraw. Ms. Reed.
Thank you, Your Honor. We are requesting withdrawal from this matter. There's been a breakdown of the attorney and client relationship, and my client has failed to meet his financial obligations to the firm.
Mr. Concrete, you have any response?
I've spent over $15,000 trying to pay for lawyers, and with the other lawyer that I had, Paula, that I had represent me in the appeal. I literally have no more money. I've spent all my money trying to do the best I can for my daughter and keep her away from people she doesn't want to be around. And yeah, I've done the best of my ability to be the best father, but yeah.
Okay. Mr. Bartell, I don't assume you'll have any opposition to Ms. Reed withdrawing.
No, I don't have any opposition. My only note is, Your Honor, there's an outstanding order regarding the counselor that I have not received from the other side. Mr. Umlauf had appeared and I've had no communication. I had sent him an email and there's been no response as to selecting the counselor. So I just note that, Your Honor. And then the second part is I'm just asking that there be no further adjournments of the hearings
Well,
because there's been several adjournments.
Yeah.
Yeah.
We don't want to adjourn the matter, so I will grant Ms. Reed's motion to withdraw, and we will proceed as scheduled in this matter. Okay, you're free to
All
go.
right,
Have a
thank you.
good day.
On September 23rd, they had day 1 of their big evidentiary hearing, which you can watch in part 1 and part 2 of these videos. You don't want to miss that wild ride. I will link them in the description box below, just in case you haven't seen them yet, because you do not want to miss the crazy testimony in that evidentiary hearing. In my 2 videos, we hear testimony from both the stepmom and mom, as well as the maternal grandparents and several other relatives. But the hearing did not conclude that day, and they schedule a day 2. On day 2, October 1st, they heard from more witnesses, including Dad. But in the end, they worked out an agreement for the grandparents to have weekend parenting time, and they would also pay for the counseling sessions if they aren't covered by insurance. I will link part 3 down below too.
Court will note the appearance of Ms. Reed on behalf of the plaintiff, Mr. Bartell on behalf of intervening parties in this matter, as well as the defendant. This matter is before the court on defendant's notice for entry of order regarding parenting time. Ms. Reed, are you objecting to the order?
We are, Your Honor. I have not been able to talk to my client since the hearing. However, it's my understanding of the agreement is that the grandparenting time would terminate upon mom's release from prison, since we are essentially adopting the temporary order that the court had ordered previously. So we're requesting that that language be added, or language be added that if we're not going to terminate the grandparenting time when mom's released, since there might be like a reintegration period, that grandparenting time coincide with mom's weekend parenting time. Because the effect of the order as written right now is upon release, mom would be expanding her parenting time to every weekend, and the grandparents would be getting every weekend. And that's our concern, and that's not what my client agreed to.
Okay, Mr. Bartel, what's your response?
Your Honor, we put on the record after there was negotiations, I put in our proposed order exactly what we had agreed upon. I guess if the court wants to go back and listen to that, that is exactly what was put on the record. What Ms. Reed is suggesting is now going into a different area that we had never discussed or agreed upon with regards to this. So I just put everything that we had agreed upon, and I'd ask that the order be entered. If the time comes that Ms. Morgan is released from prison, then I guess we can address it at that time. And I say that because, unfortunately, plaintiff in this matter, at least from my perspective, for whatever it's worth, is he's played games and likes to do these little things. And as Ms. Reed hasn't even indicated, she hasn't even talked to her client since that hearing. She can't even get a hold of her client, yet they're objecting. They did not file a written objection and a proposed alternate order. So I'd ask that our order be entered.
Well, I guess to eliminate and address Ms. Reed, obviously there wouldn't be the intent that there was no intent, I think, for, let's say, the grandparents to have alternating weekends and then mom having alternating weekends when she got out of prison. Perhaps the best thing to do is maybe modify the order that states that in fact the interveners would have the parenting time, those alternating weekends, until such time as her parenting time resumed. That way, if there's a delay after she gets out, then it doesn't mean it doesn't end at the time that she gets out of prison, but at the time it would simply, their parenting time would end at the time that she commenced receiving her parenting time as well. So I guess I'd ask Mr. Bartel if you would modify the order to include that.
Okay.
And resubmit it under 7 days, then we can get that entered.
Okay, I will. Thank you.
Thank you.
All right, thank you.